Brill. Right, I welcome members to the fifth meeting in 2014 of the Delegated Powers and Law Reform Committee. As ever, ask members to turn off mobile phones. Agenda item 1 is a decision on taking business in private. It's proposed the committee takes item 9 in private. This is consideration of the High Speed Rail London West Midlands Bill UK parliamentary legislation and a draft report we have in front of us. Does the committee agree to take that in private, please? Agreed. Thank you. Agenda item 2 is instrument subject to negative procedure. No points have been raised by our legal advisers on the Act of Subordinate Fees of Solicitors in the Sheriff Court Amendment 2014 SSI 2014, nor on the designation of regional colleges Scotland Order 2014 SSI 2014-22. Is the committee content with these instruments, please? Thank you. Agenda item 3 is instruments not subject to any parliamentary procedure. No points have been raised by our legal advisers on the Act of Subordinate Rules of the Court of Session Amendment Fees Solicitors 2014, SSI 2014-15, nor on the Post-16 Education Scotland Act 2013, Commencement Number 3 and Sanitary and Saving Provisions, Order 2014, SSI 2014-21. Is the committee content with these, please? Okay. Thank you. Agenda item 4 is the Revenue Scotland and Tax Powers Bill. The purpose of this item is for the committee to consider the delegated powers in the Revenue Scotland and Tax Powers Bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the Scottish Government on the delegated powers in the bill. It's suggested these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill. The committee will have the opportunity to consider the responses at a future meeting before the draft report is then considered. The committee may wish to note that, in keeping with the Standing Orders requirements, the Delegated Powers Memorandum only covers powers to make subordinate legislation. Therefore, the powers contained in this bill to issue guidance are not discussed in the Delegated Powers Memorandum. The committee may therefore wish to seek further explanation on these powers from the Scottish Government. Section 8 of the bill sets out that ministers may give guidance to Revenue Scotland about the exercise of its functions, and the body must have regard to that guidance. The guidance provided must be published as considered appropriate by ministers, unless they consider that to do so would impact on the ability to carry out the functions effectively. Stuart.
Thank you, Convener. I think I can understand that there may be circumstances where the publication of the guidance would inhibit the ability of Revenue Scotland to recover all due tax. But I think in Parliament's consideration of whether it's appropriate for Minister to have the decision-making power not to publish certain parts of their guidance, it would be appropriate for us to ask ministers to help us understand under what circumstances they would exercise that discretion not to publish guidance to Revenue Scotland.
Indeed. Well, does the committee agree to ask the government what the purposes of this power are and how the power could be exercised, and why the section provides for the publication of the guidance but does not provide for a copy of it to be laid before Parliament? Thank you. Section 11.7a allows Scottish ministers to set the period that Revenue Scotland's first corporate plan will cover. Corporate plan will set out Revenue Scotland's main objectives, the outcomes that would demonstrate achievement of those objectives, and the activities that Revenue Scotland expects to undertake. The Delegated Powers Memorandum states that the power is required to specify a planning period to which the corporate plan of Revenue Scotland will relate of less than 3 years, and that it is intended that the planning period of the second plan would start from the 1st of April 2018. However, the scope of the power allows any first planning period to be specified by order, whether less or more than 3 years. Does the committee therefore agree to ask the Scottish Government why this power should not be drawn more narrowly to permit a first planning period of 3 years or less to be specified?
Agreed.
Section 41 provides that the tax tribunals are to sit at such times and in such places as the President of the tax tribunals may determine. The committee may also wish to note that a different approach is taken in the Tribunal Scotland Bill for the first tier tribunal and upper tribunal for Scotland. Section 56 of the bill provides that each of the first tier tribunal and upper tribunal may be convened at any place in Scotland to hear or decide a case or for any other purpose relating to its functions. that is also subject to any provision made by the tribunal rules as to the question of where in Scotland Scottish tribunals are to be convened. Does the committee therefore agree to ask the Scottish Government why the power in Section 41 is proposed, and why the power is formulated differently as compared to the power in Section 56 of the Tribunal Scotland Bill to determine the venue and timing of hearings of the First Tribunal and Upper Tribunal for Scotland?
Agreed.
Section 45(1) confers a power on Scottish ministers to confer such additional powers on the tax tribunals as are necessary or expedient for the proper exercise of their functions. Subparagraph 2b provides that the regulations can include provision causing Part 1 of the Scottish Civil Justice Council and Criminal Legal Assistance Act 2013 to apply to the making of a relevant act of sederant, as it does to the making of tribunal rules under the Bill. Part 1 established the Scottish Civil Justice Council. The Court of Session must consider any draft civil procedure rules submitted to it by that council. Does the committee agree to ask the Scottish Government what the purpose of the provision is, why it is appropriate to be included in regulations under subsection 1 rather than conferring a power to make an act of sederant in relation to the tax tribunals to which that part of Part 1 could be applied, and what a relevant act of sederant refers to, as the section does not define that term?
Agreed.
Give me half a moment. Section 54 provides that the President of the tax tribunals may issue guidance about the administration of the tax tribunals as appears necessary or expedient to secure the functions of the tribunals are exercised efficiently and effectively. Does the committee agree to ask the Scottish Government why there is no provision for the publication of the guidance, unlike, for instance, Section 52(4) on the publication of practice directions, nor for laying a copy before Parliament upon issue? And why, though it is specified in the section that the guidance has the purpose of securing that the functions of tax tribunals are exercised efficiently and effectively, there is no provision that any specified person have a requirement to take regard of it? Are we agreed on that? Thank you. Section 69 provides for the duty of a person who is required to make a tax return for a devolved tax to keep any records needed to enable the person to make a correct and complete return and to preserve those records. Section 69(2) provides the records must be preserved until the end of the later of the relevant day and the date on which an inquiry into the return is completed, or a designated officer no longer has power to inquire into the return. Section 69(3) states that the relevant day is the 5th anniversary of the day the return is made, or a notice of amendment of that return is given, or an earlier date that may be specified in writing by Revenue Scotland. The duty under Section 69 to preserve records may be satisfied by preserving them in any form and by any means. Section 70b provides the duty may also be satisfied by preserving the information contained in the records in any form or by any means. Section 70b states that that is subject to any conditions or exceptions that may be specified in writing by Revenue Scotland. This enables Revenue Scotland to specify the form or means by which information contained in tax records may require to be kept. In relation to both Section 69(3) and 69(3) and 70b, therefore, does the committee agree to ask the Scottish Government why these powers are appropriate in principle and why they should be exercisable by Revenue Scotland rather than by Scottish ministers, why the powers should be exercisable by informal written specification, which is not subject to parliamentary procedure, rather than a form of subordinate legislation, and why there is no provision for appropriate publication of these written specifications.
Agreed.
Unjust enrichment may occur where a repayment of tax is made to a taxpayer, but the taxpayer has not ultimately borne the cost of the tax. Section 100 provides that unjust enrichment would be a defence against a claim for repayment of tax. Section 102 enables regulations to be made under which certain reimbursement arrangements may count for the purposes of Section 100, so do not allow Revenue Scotland to defend a repayment claim on the ground of unjust enrichment. These regulations may provide for the conditions the reimbursement arrangements must comply with, and for other arrangements to be disregarded for the purposes of Section 100. Section 103 provides that the regulations may make provision for penalties for breach of regulations under Section 102. Does the committee agree to ask the Scottish Government why the power in Section 103(2) enables any amount of a penalty, including daily penalties, to be imposed by regulation, and why the power could not be drawn more narrowly to provide for suitable maximum penalties. And given the width of the power in that respect, whether the affirmative procedure could be a more suitable level of scrutiny of the regulations than the negative procedure. It's noted in comparison that, for example, the powers to change fixed amounts of penalties in section 171 are subject to the affirmative procedure. Stuart.
Convener, it's clear that different parts of what's before us, in some cases primary legislation specifies an amount, in other cases it's left to secondary legislation. I think it would be more satisfactory if there was a consistent approach to this, whereby probably the amount, an amount was specified in the legislation, albeit with the power to modify it by secondary legislation, or they're all excluded and all specified by secondary legislation. So I think that's a general observation that I hope the official report will suffice to carry forward.
Indeed, I hope it will, and I think our questions will allow the government to answer if you're happy that we ask the government those questions.
Agreed.
Thank you. Power at section 1502 allows ministers to make further provision about penalties for a failure to make a tax return on or before the filing date, as defined in section 73(3) of the bill. Further provision can include the circumstances in which such a penalty is payable, penalty amounts and types, arrangements for issuing, appealing and enforcing such a penalty. Does the committee agree to ask the Scottish Government why the provision enables any amount of penalty, including fixed or daily penalties, to be imposed by regulation? So why the power could not be drawn more narrowly to provide initially for suitable maximum penalty amounts in relation to the two taxes which are currently devolved, and why, similarly, the bill could not specify initially the circumstances in which a penalty is payable, where a person fails to make a tax return by the filing date in respect of the two devolved taxes.
Agreed.
Thank you. Power at section 151(2) enables ministers to make further provision about the penalties for the failure to pay tax on or before the due date, including the circumstances in which such a penalty is payable, penalty amounts and the types, and also arrangements for issuing, appealing and enforcing such a penalty. Does the committee agree to ask the Scottish Government why, as with the previously discussed power at section 152, the provision enables any amount of penalty, including fixed or daily penalties, to be imposed by regulation, and so why the power could not be drawn more narrowly to provide initially for suitable maximum penalty amounts in relation to the two taxes which are currently devolved, and why again the bill could not specify initially the circumstances of which a penalty is payable where a person fails to pay tax by the due date in respect of the two devolved taxes.
Agreed.
Thank you. Section 167 allows the ministers to make further provision about penalties applicable where a person submits a relevant document containing one or more errors which amounts to or leads to an understated tax liability or a false or inflated claim for relief. The error must be careless or deliberate. The penalty is payable for each error or inaccuracy in the document. Scottish ministers have power to make further provision specifying what relevant documents are, penalty amounts, and also arrangements for issuing, appealing and enforcing such a penalty. Similarly, section 162(4) allows ministers to make further provision about penalties applicable where a person submits a relevant document containing one or more errors which understate the tax liability or provide a false or inflated claim for relief, but where the error is attributable to another person. Penalty is payable by that other person where they have deliberately supplied false information or withheld information from the person who submitted the document. Ministers have power to make further provision specifying what relevant documents are for the purposes of sections 167 and 162(4), the penalty amounts and also arrangements for issuing, appealing and enforcing the penalty. With regard to both sections 167 and 162(4), does the committee agree to ask the Scottish Government why these provisions enable any amount of penalty to be imposed by regulation, and so why the powers could not be drawn more narrowly to provide initially for suitable maximum penalty amounts, and why the power is appropriate to specify relevant documents which amount or leads to circumstances set out in sections 162 or 162(1) arising, and how this power could be exercised.
Comment.
Stuart.
Just looking at the way the bill is drafted, Convener, it's a very minor point, but a point of some curiosity. That the person who's paying the tax is designated as person P, and the person who is creating the error is designated as person T. And I'm very unclear why these choice of letters is made. They seem to bear no relationship to anything sensible. And I just want to put that in the record. I don't think we should take any action.
Grateful for your observations. Not quite sure what I'm going to do with them. Nonetheless, I do have to ask the committee whether it's happy to ask those questions, please.
Agreed.
Thank you. Section 163(3) allows the ministers to make further provision about penalties applicable where a person fails to take reasonable steps to notify Revenue Scotland about a Revenue Scotland assessment which understates the tax liability. Ministers can make further provision specifying what relevant taxes are, devolved taxes, for the purposes of this penalty. They may also prescribe the penalty amounts and the arrangements for issuing, appealing and enforcing such a penalty. Does the committee agree to ask Scottish Government why the power enables any amount of penalty to be imposed by regulation, and so why the powers could not be drawn more narrowly to provide initially for suitable maximum penalties?
Agreed.
Section 1812 allows the ministers to make further provision about penalties for a failure to register for the Scottish landfill tax. Ministers can make further provision specifying penalty amounts and the arrangements for issuing, appealing and enforcing such a penalty. Does the committee agree to ask the Scottish Government why this power enables any amount of penalty to be imposed by regulation, and so why the powers could not be drawn more narrowly to provide initially for suitable maximum penalty amounts?
Agreed.
The power at Schedule 2, paragraph 21(1), will enable provisions in connection with the investigation and determination of any matter concerning the conduct of members of the tax tribunals and the review of any such determination. Paragraph 21(2) makes provision about what the rules may cover in particular. Paragraph 22b provides that the rules are to be published in such manner as the ministers may determine. Paragraph 23 sets out the possible consequences of an investigation. Similar power in Schedule 2, paragraph 31, enables the procedures to be followed as a fitness assessment tribunal to be set out in rules. The ministers will have responsibility for constituting a fitness assessment tribunal when requested to do so by the President of the tax tribunals. Its function is to assess whether a person is fit to hold a position of member of the tax tribunals. The Delegated Powers Memorandum states that the intended procedure applying to those rules is not laid no procedure. However, the default position provided for by sections 27 and 30 of the Interpretation and Legislative Reform Scotland Act 2010 is that rules made by Scottish ministers under enactment are made as a Scottish statutory instrument, which is laid before Parliament. With regard to both Schedule 2, paragraph 21(2), and Schedule 2, paragraph 31, does the committee agree to ask the Scottish Government for clarification of the parliamentary procedure intended to apply to these rules and whether the provisions achieve that procedure? If it is proposed that the rules are not to be laid, why is that more appropriate than rules being laid and made by Scottish statutory instrument? And why is there provision for publication of the rules under paragraph 21, but not so under paragraph 31? Thank you very much. That completes a lengthy list on a bill, and I'm hoping we can manage to change the procedures so we don't have to do that terribly often. I'm looking at the convener of the Standards and Procedures Committee as I say that.
Indeed.
I would just
John.
say that it's very important to have these matters firmly on the record for the avoidance of doubt.
Can I say, John, there's no doubt that we would get these matters on the record, but we do it other ways, and we can do it without having to read them out, which I think is what really is being proposed. Thank you for your patience. Agenda item 5 is the Children and Young People Scotland Bill. This item of business is consideration of the delegated powers provisions in this bill after stage 2. Members will have noted the Scottish Government has provided a supplementary delegated powers memorandum and will have seen the briefing paper. Stage 3 consideration of the bill is due to take place on Wednesday the 19th of February. The deadline for lodging amendments is 4:30 on this Thursday the 6th of February. The committee may therefore wish to agree on its conclusions today. There are a number of powers to which the committee is invited to give particular consideration. Section 52(2)(b) allows the Scottish ministers to modify Section 52(1) by order to confer, remove or vary a duty on corporate parents. power also allows ministers to provide that Section 52(1) is to be read in relation to a particular corporate parent or corporate parents of a particular description, with any modification conferring, removing or varying a duty. At present, the bill applies all duties to all corporate parents. A further power will allow ministers to alter this one-size-fits-all model so as to tailor the duties to specific corporate parents or classes of corporate parent. The power is framed in a way which suggests that the duties will become fragmented between primary legislation and the modification in subordinate legislation. The committee may consider that the proposed structure lacks transparency and could lead to confusion in determining which duties are owed by which authorities.
Comments? Convener, it would seem in the light of the way this has been drafted that it might be appropriate for us to agree that where such lists are capable of being modified by secondary legislation, unless there's an overriding reason, the complete list should be included in any secondary legislation, even if parts of the list merely represent what existed already, so the list is in a single place.
Thank you for that suggestion. I'm sure the government will give this some thought. I'm suggesting that the committee agree to report that whilst it finds the power in section 52(2)(b) to be acceptable in principle, it's concerned that the structure proposed by the power of a mandatory list of duties in primary legislation applied as modified by standalone subordinate legislation could lead to confusion and impede clarity.
Agreed.
Thank you. Section 60A inserts a new section 26A into the Children Scotland Act 1995. New inserted section 26A places a duty on local authorities to provide continuing care to eligible persons who cease to be looked after by them. The provision confers several powers on Scottish ministers within this framework. Ministers may specify the upper age limit of eligible persons and the period for which the duty to provide continuing care subsists. Ministers may also modify the bill to provide that when the duty to provide continuing care does not apply or when it ceases. These powers are subject to the affirmative procedure. The duty to provide continuing care for looked after children is a significant addition to the bill. Within the framework provided by the bill, there are a number of powers which are themselves of importance in structuring the scope and application of the duty over time. As a result of these being inserted in the bill at stage 2, the committee does not have the opportunity to scrutinise the purpose of the power and its effects as effectively as at stage 1, since time does not permit that. Powers offer maximum flexibility to ministers to structure the duty and to vary the application of the duty over time in a manner they consider appropriate. Whilst it is understood that ministers intend to roll out the duty to different cohorts over time, the power could be used very differently. Each of the powers is subject to the affirmative procedure, which affords a high level of scrutiny and for active involvement by the Parliament, but there is no requirement for consultation with local authorities, social care and social work improvement Scotland, or persons who may be effective. The committee may consider that the subject matter is of sufficient importance that some prior consultation with such persons should be required when using the delegated powers to alter the scope of the duty. This could also assist the Parliament in its scrutiny of proposals for the rollout of that duty. Does the committee therefore agree to express concern in its report that powers of this significance have been added at stage 2, which have reduced the scrutiny which the committee has been able to apply? Does the committee also agree to recommend that there should be a requirement for consultations with local authorities, social care and social work improvement Scotland, and persons representing the interests of looked after children before the powers are exercised?
Agreed.
Thank you. A new power has been inserted into section 13C3 of the Adoption and Children Scotland Act 2007 by amendment at stage 2. This provision permits ministers to prescribe circumstances in which adoption agencies will not be required to disclose information relating to Scotland's adoption register, despite the general duty to do so set out in section 13C1. This change could be considered significant in terms of ensuring the disclosure regime is compatible with ECHR rights. On introduction, the bill required consent to disclosure to be obtained from the child's parents and any other prescribed person. The requirement to obtain consent to disclosure has now been removed from the face of the bill. In its place is a power which permits the Scottish ministers to prescribe the circumstances in which prescribed information is not to be disclosed. This could include provision about the need for consent, but need not require it. It should be noted that the bill already confers powers on the ministers to require the information to be disclosed to a third party instead of to them. By removing the consent requirements from the face of the bill, the Parliament has given up its control over them to Scottish ministers. The committee may consider this to be an issue of importance. Does the committee agree to express its concern that the requirement for consent to be obtained for disclosure under Section 13C of the Adoption and Children Scotland Act 2007 has been removed from the face of the bill and has been replaced with a FOW which enables ministers to prescribe those circumstances in which disclosure is not permitted, but which does not require consent to disclosure to be obtained?
Good.
John?
I would just like to endorse concerns on that, and my concerns being that we may have moved from a situation which is demonstrably ECHR compliant to a position which is perhaps less obviously ECHR compliant, and given a recent track record of ECHR compliance, I think it's important that we make every endeavour to make certain that legislation we are producing is absolutely and self-evidently ECHR compliant.
Thank you. John? Sorry, Steve.
I recognise what John is saying in relation to Article 8 of the European Convention on Human Rights and the right to privacy. But there is a difficulty here, but the issue of ECHR compliance or non-compliance is one that will arise by the interaction of the commencement order. If there is a commencement order, it will be a commencement order for Section 68 of this Act, which puts 13DA into the 2007 Act, and any subsequent secondary legislation. So while it's perfectly proper to put comment on the record today, it is clearly the risk crystallises when we come to these two orders at a later date.
Indeed. It is suggested that the committee may wish to be content with all other provisions in the bill, which has been amended at stage 2, to insert or substantially alter provisions conferring powers to make subordinate legislation. Are we content to report accordingly? Yeah, thank you. That brings us to agenda item 6, which is the Marriage and Civil Partnership Scotland Bill. As members will recall, the committee agreed in its report on the Marriage and Civil Partnership Scotland Bill as amended at stage 2 at last week's meeting. In its report, the committee invited the Scottish Government to respond in relation to two matters relating to the laying of draft orders for consultation before Parliament. Members have seen the response from the Scottish Government, and I'm wondering whether any have any comments, please. John?
For my part, I'm content with the Government's explanation and the fact that they are considering bringing forward. Is it this one they're considering bringing forward an amendment? No, I beg your pardon. I'm content with the Government's explanation. I'm sorry, thinking of another piece.
Yeah, thank you. Are we agree to note the Scottish Government's response?
Content to that.
Yeah, thank you. Agenda item 7 is the Criminal Justice Scotland Bill. This item of business is consideration of the Scottish Government's response to the committee's Stage 1 report on the Criminal Justice Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Do members have any comments on this one, please? Yeah? Are we content?
Amendment at stage 2, possibly.
Yep. Thank you. Are we content to note the response and, if necessary, reconsider the bill after stage 2?
Content.
Thank you. Agenda item 6 is Deep Sea Mining Bill, which of course is UK Parliament legislation. Under this item, the committee is invited to consider the powers to make subordinate legislation conferred on the Scottish ministers in the Deep Sea Mining Bill. A briefing paper has been provided that sets out the relevant aspects of the bill and comments on their effect. Again, do members have any comments, please? No. Do members agree to report to the Lead Committee that it is content with the delegated powers conferred on Scottish ministers in the bill and that they are subject to the negative procedure?
Content.
Yeah, thank you. That completes item 8, and therefore we move into private for item 9. Thank you very much.